evening, good morning, good afternoon, Gary, and our viewers from all around the world. I'm delighted to welcome you to today's webinar. I know many of you continue to work from home, and we appreciate that you have taken the time to tune in. I just took a quick look at the attendee list for today's webinar, and we have thousands online right now, from Albania to Zimbabwe, literally A to Z, spanning 6 continents. I see on the list many GCs, in-house counsel, practitioners, and arbitrators from Singapore, Asia, Africa, Australia, Europe, the Middle East, US, UK, and South America. It is my great privilege and pleasure today to be moderating this masterclass on drafting international arbitration agreements by Gary Bourne, President of the SIAC Court of Arbitration. As someone who needs no introduction, and with Gary's permission, I will use the time I would otherwise need to read through all of his numerous accolades and accomplishments to tell you about SIAC and what we've been doing during COVID-19. It has been business as usual for us. In fact, it has been a very busy period for us. Cases are being filed. We continue to receive and handle emergency arbitration applications. Several have come in during the last few weeks and proceeded via virtual hearings. Parties are going ahead with expedited procedure requests, applications for consolidation, and other procedures under our rules. We are fully operational. Our staff are still telecommuting, although from this week onwards, with the gradual lifting of the circuit breaker measures here in Singapore, our physical office will be open twice a week during limited office hours to facilitate, where necessary, the delivery of physical copies of documents. Although that said, communications by email are still very much appreciated, encouraged, and the default. We have been staying in close contact with you, our users, through our webinar series, through dialogues with the SIAC Secretariat, our virtual hearing sessions with our Users Council, Young SIAC mock virtual hearings, as well as webinars in various languages. Our live help desk on the SIAC website, where you get your questions answered in real time during office hours by one of our counsel from the Secretariat, has been very popular too. As always, we welcome your feedback. Tell us what we are doing right, what more we can do, and what we can do better. And now, after this short commercial break, let me turn to today's topic. I won't give you, well, any spoilers. What I will do, however, is to wear my former GC hat and ask Gary questions as we go along. I invite you to send us your questions during this interactive session, and we will either take them during the presentation or answer them at the end. So over to Gary.
Thank you, Seok Hui, and thank you all from Albania to Zimbabwe or Zambia for taking the time to attend this. I know, given the geographical spread, that it's very early in the morning for some of you, perhaps in the Americas, late in the day, evening perhaps for those of you in Australia, China, elsewhere. I think that's appropriate though, because what we're talking about today is drafting the arbitration clause, and as we all know, usually that's the last thing that the GCs or corporate counsel that are putting together a transaction get to. It's 11:59, or the way the world works, very early in the morning, when people turn to dispute resolution provisions, hoping that, in fact, as usually is the case, they never need to be used. Despite that, despite the fact that arbitration clauses, other dispute resolution provisions are usually the last thing on deal counsel's to-do list, they're extraordinarily important. Once a dispute arises, they can have an exceptional influence on how disputes are resolved, what the parties' agreement is really held to mean. We're going to look today at how one drafts an arbitration clause, as well as what some of the alternatives are. We're going to take this in a systematic fashion, step by step, using the slide deck that I think has now been shared with all of you. Let's start with that deck and begin with the fundamental question: why is it that we plan for dispute resolution? Most parties hope, and in the majority of situations, that hope is realized, that no disputes will ever arise. Their arbitration agreement, like an umbrella, at least in some places, will never have to be taken out. Nonetheless, disputes do occur, and a forum selection clause or international arbitration agreement, especially in cross-border transactions, is essential. It provides both commercial certainty, or at least reduces the commercial uncertainty that can come from having multiple court proceedings in different jurisdictions. It ensures that a single centralized tribunal will resolve all the disputes arising out of the parties' commercial arrangement. It hopefully selects a tribunal that has appropriate expertise and experience in the subject matter of the parties' dispute. It avoids the possibility of litigation or some other form of dispute resolution in a forum that is inimical to one party, hostile to one party, or that simply lacks basic standards of either expertise or integrity. And finally, it hopefully, if one is planned properly, produces an enforceable result, a result that is enforceable both at the agreement stage and the award stage. And thus, almost every cross-border transaction mandatorily requires a dispute resolution provision, provisions that select the place, the forum in which a dispute will be resolved, and also selects the applicable law, the applicable substantive law that provides the standards by which that dispute will be resolved. With that backdrop as to why one plans for dispute resolution, let's look at the different kinds of choices one has in drafting a dispute resolution provision. And let's start with the elements of an effective international arbitration agreement. What are the questions that arise for either corporate counsel or in-house counsel when it comes at the 11th hour to drafting a dispute resolution provision? The first, and in a sense most basic question is, does one want an international arbitration agreement, or alternatively, does one want a choice of court or forum selection agreement, an agreement that provides that all disputes will be resolved in the courts of a particular jurisdiction? It may not come as much of a surprise, but given that this is an SIAC webinar, but most experienced corporate counsel, most experienced GCs tilt fairly decidedly towards arbitration as opposed to litigation. The reasons are summarized on the current slide. They can be reduced, though, to what at SIAC call the 5 E's. Arbitration tends to be more expeditious, more efficient, more expert, more even-handed, and more enforceable than the alternatives: jurisdictional disputes in national courts, difficulties in enforcing forum selection clauses, and ultimately national court judgments, the possibility of lack of expertise, the length of appellate proceedings, and the like. Those various considerations tilt most parties in cross-border transactions towards selecting an international arbitration clause as opposed to a choice of court or a forum selection clause. The party's ability to tailor the procedures in the arbitration, to choose the arbitral tribunal as opposed to randomly being assigned a national court judge, to choose decision makers with particular expertise in the subject matter of their contract, as well as the New York Convention and national law that gives robust effect to international arbitration agreements and arbitral awards. Having made that basic decision to choose an arbitration agreement as opposed to a forum selection provision, what then are the elements of that agreement? How is it that you draft an arbitration agreement? You can see on the preceding slide the list of the basic elements that one has to consider, one must consider in drafting an international arbitration provision. The first of those, and in some ways the most important, as you can see, is the seat of the arbitration. There are a number of other very important points. You can see these on the current slide, but let's start with the seat of the arbitration or place of the arbitration. In many ways, this is the single most important choice in drafting an arbitration clause. Other aspects of the arbitration provision are important, but the seat of the arbitration defines a number of critical legal and practical aspects of the arbitration. Most importantly, it is in the seat of the arbitration and only in the arbitral seat that proceedings to annul the arbitral award at the end of the arbitration can be brought. There is, of course, an enormous difference between courts in different jurisdictions. That's one of the reasons one wants a forum selection provision or an arbitration clause in the first place. But an arbitration clause can prove to be of little value if it's provided for arbitration in a jurisdiction where, once the proceedings are done, a national court can essentially relitigate the party's dispute. And thus, selecting a seat which has appropriate annulment provisions, national courts experienced in international arbitration, is essential. In addition to annulment of the arbitral award in the arbitral seat, but nowhere else, national courts in the arbitral seat can also, in many cases, consider challenges to remove arbitrators, and in ad hoc arbitrations, appoint arbitrators. The arbitral seat also defines whether or not the award will ultimately be subject to the New York Convention and its pro-enforcement regime in 162, 163 countries around the world. The national courts in the arbitral seat also can provide ancillary support for the arbitral process as part of what's called their supervisory jurisdiction. In some jurisdictions, the national courts in the arbitral seat may intervene in the arbitral process, selecting an arbitral seat where not just proper annulment standards and standards for removal of arbitrators are applied, but also where local courts will not intervene in the arbitral process is essential. There are some tips that one has to have regard to in selecting the arbitral seat. One should refer to the seat or the place of arbitration, as opposed to using other words that one sometimes sees. Occasionally one sees references to the arbitration taking place in a particular jurisdiction, or the venue or situs of the arbitral hearings being in a particular state. Those sorts of formulations should be avoided. They can suggest that all you have done is select the physical or geographical location for the arbitral hearings, not the legal home or juridical home of the arbitration, not the seat of the arbitration. And leaving open the question of where the arbitral seat may be is typically ill-advised. It may result in the arbitral seat being selected either by a national court in a jurisdiction which asserts jurisdiction over the parties, or alternatively by an arbitral tribunal who selects a seat ill-advisedly. It is always almost essential to include a selection of the arbitral seat in an arbitration agreement, and do so by referring specifically to the seat of the arbitration or the place of the arbitration, as opposed to using words like venue, forum, or situs. Singapore courts, on this issue as on others, often are of considerable assistance in resolving disputes about where the arbitral seat is. They'll interpret references to venue and the arbitration being in Singapore as references to the arbitral seat, which makes sense, but not all national courts adopt that approach. And therefore, it is best to refer specifically to the place or the seat of the arbitration in your arbitration agreement.
Jerry, can I just interject here? So, wearing that former GC hat, the seat of the arbitration, and you were talking about venue, if I choose the seat as, say, Singapore, do I have to have all the hearings in Singapore? Does the venue have to follow the seat in that regard?
That's an excellent question, and it is one that comes up fairly frequently. The answer is no, particularly in Singapore and other UNCITRAL model law jurisdictions. The seat of the arbitration is essentially a choice of law provision. It selects the procedural law of Singapore or the arbitral seat, but it does not limit where the hearings in the arbitration or the deliberations of the arbitral tribunal need to occur. That's made explicit in the UNCITRAL model law. You can see it in Article 20, subparagraph 2 of the model law, also applicable in Singapore. It's also made explicit in the SIAC rules in Rule 21, subparagraph 1. In all those cases, the arbitral tribunal has the discretion for the convenience of the parties to hold hearings outside the legal seat, the legal place or home of the arbitration. That won't change the place where annulment applications may and must be filed. It won't change the courts that have supervisory jurisdiction over the arbitration, but as a physical matter, it will change the location of the hearing venue, often simply for the convenience of the parties.
Could I also ask then, I've seen some clauses where it says the arbitration shall be in Singapore. What does that mean? Is that a reference to the seat or the venue?
That's a good question again. And it is one of the sorts of things that one ought to avoid in drafting arbitration provisions. One ought not to say the arbitration shall be in or shall be held in or conducted in either Singapore or New Delhi or New York. Those provisions can be interpreted, going back to your previous question, as simply a reference to where the hearings will be conducted. The hearings will be in Singapore or in New Delhi. And the proper approach, the better drafting approach, is to provide that the arbitral seat is Singapore or the place of arbitration is Singapore. Some national courts, Singapore courts, and you can see the reference on the current slide to the B&A versus B&B case, will interpret provisions like that, arbitration in Singapore, to mean the arbitral seat is Singapore. And that's a commercially sensible result. Parties don't typically, before any dispute has arisen, try and figure out where the most convenient place to resolve that dispute would be. Parties typically at the stage of drafting an arbitration agreement are thinking about the more fundamental question of where is the legal home of the arbitration? Where will annulment and removal of arbitrators occur? And thus the Singapore Court, the Court of Appeal, was quite right, I think, in interpreting arbitration in Singapore to mean Singapore is the seat of the arbitration. But just because the Court of Appeal got it right in that case doesn't mean that national courts in other jurisdictions will always get it right with any given language. the drafting advice in order to avoid problems and also litigation like that which had to occur before the Court of Appeal is to use a tried and tested formula. The place or the seat of arbitration is Singapore. Note that those two formula, the place of arbitration or the seat of the arbitration, the arbitral seat, are synonymous. They're identical. You can use them interchangeably.
All right, that's very helpful. Can I just ask, if I'm drafting a clause and I say arbitration in Singapore, does that automatically mean SIAC?
That's a
administered?
That's a good question. It's one that we at SIAC get fairly frequently. It doesn't. There are other arbitral institutions with their branch offices in Singapore. And Singapore, like most countries in the world, recognizes fully the possibility of ad hoc arbitrations. Simply seating your arbitration in Singapore doesn't direct you either to SIAC or to any other arbitral institution. If you want an institutional arbitration, as we're going to see in the next set of slides, you need to choose a set of institutional arbitration rules. If you simply seat your arbitration in Singapore with no reference to institutional rules, you will get an institutional arbitration conducted under the Singapore International Arbitration Act. Like other ad hoc arbitrations in Singapore, you will not get an SIAC institutional arbitration. And then perhaps that's a good segue into the next set of slides and the next basic issue that one needs to consider in drafting an arbitration agreement. Do you want a so-called institutional arbitration on the one hand, or do you want an ad hoc arbitration on the other hand? There are advantages to each, although I think experienced practitioners, both corporate draftsmen and arbitration counsel, tilt pretty decidedly in favor of institutional arbitration. Institutional arbitration is conducted pursuant to a set of institutional arbitration rules, a set of rules published like the SIAC rules, which you can find on our website, or like the ICC arbitration rules, a set of institutional arbitration rules which address a number of procedural elements in the arbitration and which importantly provide for the arbitral institution, whether it's the SIAC or the ICC, to act as appointing authority in particular arbitrations. Institutional rules address a wide range of procedural issues in the arbitration, how you constitute the arbitral tribunal, how the hearings will be conducted at a very high level, the right to a hearing, the treatment of witnesses and the like, as well as addressing the costs of the arbitration. The arbitral institution will conduct a variety of functions to assist the arbitral process, including constituting the arbitral tribunal, hearing challenges to the arbitrators, fixing the costs, the fees of the arbitration, including particularly the fees of the arbitrators, scrutinizing the arbitral award at the end of the process, deciding issues with respect to consolidation, joinder, intervention, and the like. In many cases, especially in recent years, including provisions for things like expedited arbitration or emergency arbitration. All of those issues will be addressed in institutional arbitration rules, while in contrast, ad hoc arbitrations are still an arbitration. They're an arbitration in many respects, much like an institutional arbitration, but it's done without any of those institutional rules and without the support of the arbitral institution in either constituting the arbitral tribunal or addressing the procedural issues that I mentioned previously, expedited procedures, consolidation joinder, challenges to arbitral tribunals. Instead of having the expertise of an arbitral institution, one needs to go to local courts. Importantly, going back to our last set of slides, local courts in the arbitral seat to address issues concerning constitution of the tribunal if the parties can't agree on the identity of the arbitrators, challenges to arbitrators if that arises in the court of the in the course of the arbitration and the like. For the most part, most commercial parties tilt, as I said previously, quite substantially in favor of institutional as opposed to ad hoc arbitration. They consider that there are cost savings, in fact, in institutional arbitration because of the role of the institution in supervising the arbitrator's fees, the expertise of the arbitral institution in scrutinizing the award, and all the various procedural issues that get addressed by the institutional rules regarding things like expedited procedure and consolidation. Importantly, in some countries, very few, in fact, perhaps only one, China, ad hoc arbitration is, at least in a domestic setting, not permitted, which provides, at least in Asia, another potential reason to opt for institutional arbitration. One final set of tips with regard to drafting institutional arbitration clauses. Most arbitral institutions publish model arbitration provisions, provisions which, if you use them, incorporate the institution's arbitration rules. It's almost always good advice to use those model provisions. They're based on accumulated expertise that has been fine-tuned over generations, over years, and they effectively incorporate in a proper way the institutional rules that you have in mind, whether it's SIAC or some other arbitral institution. That's important because, as we're going to see towards the end of this presentation, parties with surprising frequency refer incorrectly to institutional rules. They'll use the wrong formula. They'll not refer to the Singapore International Arbitration Center, but to the Singapore International Arbitration Court or the Singapore Arbitration Commission. And although those sorts of faulty references sometimes can get fixed by an arbitral tribunal or a national court, those types of references lead to unnecessary uncertainty and litigation. It's important to refer specifically and properly to the arbitral institution. And when one does that, the institutional rules that that institution has published get incorporated into the parties' arbitration agreement, and they become contractually binding on the parties in the same way that other provisions in their contract, in their arbitration agreement, are binding on them. Perhaps we move on to the next set of slides.
Gary, sorry to interrupt. I just had to unmute myself.
Sounds like the general counsel shouting.
The pesky general counsel. Sorry, before I ask my question, we've been getting a lot of questions from the audience. Just a couple of the frequently asked ones. Yes, this is being recorded and it will be up on our website. It will be on SIAC's YouTube channel as well. For those of you who've asked that question. The second frequently asked question is, everybody is saying your slides, Gary, are tremendously helpful, and will they be made available? The short answer is yes, on request. Could you just email that SIAC events email that we've been corresponding with you? That's events@siac.org.sg. Okay, and with that, if I could just interject and ask two questions. The first one is, you mentioned in the context of institutional arbitration, one of the advantages over ad hoc arbitration is the scrutiny of awards. I don't know what that means, and why is that so important? And the second question is, you've been talking a lot about seat and institution, and I'm confused. I think if I write SIAC into my clause, does it automatically mean I have to choose Singapore as the seat?
So two great questions. Scrutiny of the award is a review conducted at the end of the arbitration by the relevant institution. Not all institutions will scrutinize the arbitral tribunal's award, but for example, SIAC and the ICC will do so. Some other institutions will not do so. Scrutiny doesn't alter or modify the arbitral tribunal's conclusions about resolution of the party's dispute. It doesn't alter the relief that the tribunal decides to grant or the reasoning for its disposition of the case. It does, however, ensure that the arbitral tribunal has addressed all of the issues that the parties have put to the tribunal, and that the formalities that may be necessary, for example, in Indonesia, for effective recognition and enforcement of an arbitral award have been complied with. It also ensures that there's a basic level of quality that is exercised by the arbitral tribunal in its reasoning in the case. It doesn't change the substantive result, but it enhances the ability of the parties to have the award recognized and enforced. With respect to the second question, by choosing an arbitral institution, for example, SIAC, one doesn't therefore necessarily choose the institution's home jurisdiction, if I can put it that way. One can, and many parties do, select SIAC's institutional arbitration rules, and SIAC is the appointing authority, the arbitral institution that administers the arbitration, but seat the arbitration somewhere else, seated in New York or London, seated in Beijing, seated in another jurisdiction. There's no necessary linkage between the arbitral institution on the one hand and the arbitral seat on the other hand.
Gary, we're getting a lot of questions from the viewers on how to determine the seat when the contract is silent on the seat. And the other one that's been asked a lot by our audience is, what happens if I have an ad hoc arbitration and I want SIAC to administer it? I changed my mind. I don't want it to be ad hoc anymore.
So let's take the first question first. Suppose that people haven't listened to this webinar and they therefore haven't taken the advice to specifically include designation of the arbitral seat in their arbitration agreement. The arbitration agreement is silent as to the arbitral seat. What happens then? What happens under the SIAC rules, which is a benefit of institutional rules generally, but specifically of the SIAC rules, is the arbitral tribunal itself is given the authority to choose the arbitral seat. In that respect, there's no presumption that the seat will be Singapore. Some other arbitral institutions, LCIA, other institutions, have a sort of presumption in favor of their own local jurisdiction, but under the SIAC rules, the arbitral tribunal has full discretion to choose that arbitral seat which is most appropriate and fairest for the parties. The arbitral tribunal can exercise that discretion after hearing from the parties. This avoids what's sometimes called the risks of a blank clause. A blank clause is an arbitration agreement that doesn't specify either the arbitral seat or the means of selecting the arbitral tribunal. And in those cases, there really is no effective way. There's some ineffective substitute ways, but there is no effective way to select the arbitral seat because there's no way to constitute a tribunal. There's no national court in an arbitral seat to appoint an arbitral tribunal, and one's left with a sort of chicken and egg problem. If you don't have an arbitral tribunal because the parties can't agree, and you haven't chosen an arbitral seat, where do you go to find a national court to provide assistance in selecting an arbitral tribunal? And the answer is nowhere. And that's one of the reasons, another one of the reasons parties prefer institutional arbitration. Even absent an arbitral seat, the institution can appoint the tribunal, and also why it makes good drafting sense to specify where the arbitral seat is. And I'd like to come back to your second question, Seok Hui, but you're going to have to remind me what that was.
That was, if it's an ad hoc arbitration in the arbitration clause, but I've changed my mind because I've been convinced by your presentation, and I actually want to change it to SIAC administered arbitration. Can I do that? How do I do that?
You can do that. It takes the cooperation of your contractual counterparty, but parties are free, of course, to amend their arbitration clause, just like they can amend other provisions in their contract to include an incorporation of the SIAC rules. Parties can also change during the course of an arbitration, can change from an ad hoc arbitration to an institutional arbitration. That's complex and requires discussions if there is an arbitral tribunal with an arbitral tribunal, and there are issues with respect to appointment and confirmation of an existing tribunal. But it is possible to do. It underscores, though, the importance of foresight in terms of drafting arbitration clauses when, at that 11th hour, when the contract is being finalized. If you're going to select institutional arbitration, the right time to do it is then, even though if you fail to do so, there are ways to do it subsequently.
And one more question from a viewer. Does, and I quote, "to be resolved through arbitration under the rules of SIAC automatically mean SIAC will administer the arbitration?"
I think that isn't the SIAC's model clause, which you can find on our website. And it's always advisable, we'll come back to this towards the end of the presentation, it's always advisable to use both our SIAC's model clause and also other institutions' model clause. That said, that clause very likely would be considered by the registrar as sufficient to permit registration of a request for arbitration and constitution of an arbitral tribunal. I don't want to obviously speak to any specific contractual language. That's the registrar's function in administering a case, not my function. And it's ultimately an arbitral tribunal's function to interpret whatever the party's arbitration provision meant. But a reference to either SIAC or to the SIAC rules is ordinarily, even if inelegantly drafted, sufficient both to start an arbitration and to constitute a tribunal, and in the vast majority of cases to permit the arbitration to go forward before the tribunal. Perhaps we slip back to the slide deck and the next set of slides, which is the scope of the arbitration clause. So far what we've done is we've chosen a set of institutional rules and we've chosen the arbitral seat. Well, what disputes are we going to submit to arbitration? Like other aspects of the arbitration agreement, this is entirely a matter, almost entirely a matter for the parties to decide, and for the parties to decide in drafting what's called the scope of the arbitration clause or the arbitration agreement. The scope of the arbitration clause defines what sorts of disputes, what range of disputes the arbitral tribunal may and conversely may not decide. And essentially the question is, do you have an arbitration clause with a broad scope or a narrow scope? Let's look at some of the potential examples that one sees in different types of arbitration agreements. Sometimes you see clauses like the first bullet point in this slide, which are drafted relatively narrowly, either all disputes arising out of this contract or alternatively, all disputes arising from this contract. Some courts have decided, some arbitral tribunals have decided that these types of formulations limit the tribunal's jurisdiction only to contractual disputes, only to disputes that arise out of the application of the specific, the express terms of the contract. They don't extend to non-contractual claims, breach of fiduciary duty claims, various kinds of tort or delict claims that may be related to the party's contract, but that don't specifically arise out of claims that its terms have been breached. Broader formulations of arbitration agreements are contained in the second two bullet points that you can see in the slide. All disputes relating to this contract, or sometimes all disputes connected to this contract, arising in connection with this contract, or if you want to have a belt and suspenders approach, the final bullet point, all disputes, claims, and controversies arising out of or relating to this contract, including all disputes relating to the formation, validity, interpretation, performance, or termination of this contract. An effort to, in a sense, ensure one-stop shopping, to make sure that all the parties' commercial disputes having anything to do with their relationship will be submitted to arbitration, will be submitted to a single arbitral tribunal, rather than taking the risk of multiple proceedings with possibly inconsistent results in different forums, national courts on the one hand and arbitration on the other hand. Therefore, the general drafting advice and what one sees in both the SIC model clause and other institutional arbitration agreements is the broader version. The particular language that one uses is often not decisive, but something that is drafted more broadly than simply disputes arising from this contract, and instead encompasses all disputes relating to this contract, sometimes with the further elaboration you see on this slide. In some cases, parties have particular reasons not to want a broad formulation, or alternatively to limit the scope of the tribunal's jurisdiction. For example, one sometimes sees in intellectual property transactions a carve-out or an exclusion for particular types of IP claims. You can see an example on the current slide. In most cases, those types of exclusions are ill-advised. Arbitral tribunals, for the most part, have very broad jurisdiction, assuming that the party's arbitration clause gives them that authority. There's very few disputes which are so-called non-arbitrable or not capable of settlement by arbitration, and therefore it typically makes sense to opt for one-stop shopping that avoids multiplicitous litigation and potentially inconsistent results. But if you do want to exclude certain matters, that type of exclusion that you see on the current slide is one approach towards it. Having addressed the scope of the arbitration clause, we can turn to another matter which is quite important, although it's not strictly speaking part of the arbitration agreement, and that is choice of law or governing law, the law applicable to the party's dispute. Note that in international arbitration, there are actually several choice of law questions. And in particular, there are three main questions, three main applicable laws. Number one, and the one that I think most viewers typically think about, the law applicable to the party's underlying commercial contract. So you have an arbitration agreement that is in a sale and purchase contract. The applicable law that defines the party's rights under that sale and purchase contract. The second issue that is related but different, the law that governs the arbitration agreement, the arbitration clause itself. Note that that can be and often is different than the law governing the underlying contract. One may think intuitively that, oh, the law of the arbitration clause, clause 21 in a 25 clause contract, must be the same as the law governing the other 24 clauses in that contract. But that's not true. The arbitration agreement is, under virtually all national laws, separable. It's independent and autonomous from the underlying contract. And parties are free to select a different law applicable to their arbitration agreement. And there's, in many cases, express choice of law provisions that do so. If the parties don't choose a different law to govern their arbitration agreement, then an arbitral tribunal or a national court must make a choice of law decision, must decide what law is applicable to the arbitration agreement. And finally, a cluster of other choice of law issues related to the procedural law of the arbitration and the law applicable to the recognition and enforcement of the arbitral award. What I'd like to focus on now, just very briefly in the time that we have, is the law applicable to the underlying contract and then also very briefly, the law applicable to the arbitration agreement. Let's look first at some of the provisions that one sees in so-called general choice of law clauses. This is on the next slide that we have. And one sees a variety of formulations which, like arbitration agreements themselves, can differ in their scope. One common formulation is, this contract shall be construed in accordance with the laws of state X. It's a relatively narrow formulation. At least if you read it literally, it only addresses questions of interpretation and construction of the contract. It doesn't, for example, necessarily address questions of performance or breach. Although I think most parties would expect that a choice of law clause would do so. A somewhat broader formulation is, this contract shall be governed by the laws of state X, thus going beyond issues of construction and reaching issues of performance, validity, and the like. In general, that better reflects the parties' expectations when they include a choice of law clause in their contract. And insofar as parties desire commercial certainty and predictability, that broader provision typically is better advised. Even better advised in most cases, however, is the final choice, the broadest of the various options we have, where the choice of law clause mirrors the terms of the arbitration agreement, thus including non-contractual disputes as well as contractual disputes within the scope of the choice of law clause. Note that all of these various choice of law clauses select the law applicable to the underlying commercial contract. They did not necessarily select the law applicable to the arbitration agreement itself. Parties can include a separate choice of law provision in their arbitration agreement. They typically don't do so, but because it is a separable agreement, they both are entitled to, and in some cases may be well advised to do so, to select often the law of the arbitral seat to govern the specific terms of the arbitration agreement, even if a different national law may apply to the underlying commercial contract. National courts, in particular Singapore and English courts, have addressed the question of what is the relationship between a general choice of law clause, like that on the current slide, and the arbitration agreement. What is the law applicable to the separable arbitration agreement in a number of cases? And although there are some bumps along the road, most court decisions seem to be heading in the direction of applying the law of the arbitral seat as an implied choice of law governing the arbitration agreement. The important point, though, I think for drafting is include a governing law clause in your underlying commercial contract, selecting the law applicable to that contract. Typically, err on the side of a broader as opposed to a narrower governing law clause. And you can see an example on the current slide. And unless our shadow general counsel, Seok Hui, has questions about this, we can move on to the next drafting topic.
Yes, I think we should move on because with an eye on the time, we have just under 30 minutes, Gary. So over to you.
I think we're in good shape. The number of the arbitrators is the next drafting question if one is drafting an arbitration agreement. The parties have full autonomy to choose the number of arbitrators to resolve their disputes, to choose the number of arbitrators in their arbitration agreement. Although they have the freedom to choose any number of arbitrators, in practice, one's talking really only about two numbers, 1 and 3. It makes no sense to choose an even number of arbitrators, 2 or 4, because of the risk that those 2 or 4 arbitrators will deadlock. There'll be a tie vote, so to speak, and the parties' dispute won't be resolved either finally or expeditiously, which is the basic purpose of an arbitration agreement. Conceivably, one could choose 5 or 7 arbitrators. Some state-to-state arbitrations do so very occasionally. commercial arbitration agreement will provide for 5 arbitrators. But in almost all cases, that is over-egging the icing or the pudding. 5 arbitrators cost a good deal more than 1 or 3 arbitrators, and they bring little additional value to the table. The real choice is between 1 or 3 arbitrators, and in making that choice, parties typically try to foresee, predict what the disputes that will arise under their contract are likely to be. If disputes are small in value, small in relative importance to the parties, relatively uncomplicated, parties almost always prefer a sole arbitrator. The sole arbitrator typically costs 1/3 as much as a 3-person tribunal, 1/3 or thereabouts as much as a 3-person tribunal. One arbitrator can coordinate his or her schedule with the parties' schedules much more expeditiously than a 3-person tribunal. And thus, in small value cases, parties prefer a sole arbitrator. Not coincidentally, expedited procedure rules under both the SIAC rules, ICC rules, other institutional rules, almost always provide for a sole arbitrator in expedited arbitrations, precisely because a sole arbitrator is much more able to conduct an arbitration quickly than a 3-person tribunal. That said, in more significant disputes, and a good rule of thumb here is the level at which SIAC will expedite an arbitration in its expedited procedure rules, around 5-6 million Singaporean dollars. A good rule of thumb is for larger disputes, disputes of a greater monetary value than that threshold, commercial parties often prefer a 3-person tribunal. They prefer a 3-person tribunal because, on the one hand, 3 heads are better than 1 in most cases. One of the loneliest jobs in the world, aside from doing webinars at home, is being a sole arbitrator and realizing how you may have missed particular points in the parties' submissions. Having 2 co-arbitrators to call your attention to matters provides a very useful check, a very useful means of quality control in a sense. Additionally, a 3-person tribunal almost always allows both the claimant and the respondent, or the claimants and the respondents, plural, to each select a co-arbitrator. That enables them to ensure that at least one member of the tribunal will have the type of background, the type of experience that they believe is essential to fairly resolve the parties' dispute, especially in international transactions where parties come from different legal cultures, different national law backgrounds, different languages. Having a diversity of views on the arbitral tribunal is important to both parties in assuring that the arbitral tribunal has the expertise and the background to fairly and in an informed way resolve their dispute. It also enables the parties to establish a tribunal that has a range of different expertises that is appropriate for their case. And thus, in almost all larger cases, parties prefer a 3-person tribunal. Of course, the difficulty is when it comes to drafting your arbitration agreement, you can't be sure whether or not the dispute that arises in the future will be a big dispute or a small dispute. Small contracts sometimes produce big disputes, and conversely, large contracts sometimes produce small disputes. And thus, there's an element of chance in trying to predict in advance how many arbitrators are the right number of arbitrators. Many parties default in those circumstances to a 3-person tribunal on the theory that it's better to have too many arbitrators in a small case than not enough in a large case that really matters. One of the other benefits of institutional arbitration is that if parties don't include the number of arbitrators in their arbitration agreement, there are default rules in the SIAC rules, UNCITRAL rules, other rules for the number of arbitrators. You can see the default provisions in the SIAC rules, and many of the default provisions give the arbitral institution the discretion to choose the number of arbitrators after a dispute has arisen. Parties sometimes seek to do that in their arbitration agreement itself, providing that if the dispute is more than a certain value, then there'll be 3 arbitrators, but otherwise there'll be a sole arbitrator. Often that is a viable way of proceeding, although it can give rise to disputes about what exactly is meant by the value of a dispute. If you are going to choose the number of arbitrators, it's relatively simple as a drafting matter to do so. You simply say the number of arbitrators shall be 1 or shall be 3. If you don't do so, as I mentioned previously though, if you don't include such a provision, then default rules in institutional arbitration rules will provide a default solution, a default number of arbitrators. And perhaps we move on now to a related topic, the arbitrators' qualifications. This is not, strictly speaking, something that is necessary in an arbitration agreement, but it is something that parties sometimes include and that in particular transactions may make sense. You can include, for example, requirements that the arbitrators have a particular legal expertise, that they be qualified in the law of a particular jurisdiction, that they have experience in a particular industry, say insurance or telecommunications or construction. You can include provisions that the arbitrators either shall have a particular nationality, they must be Singaporean, or that they won't have a particular nationality. None of the arbitrators will have the same nationality as any of the parties. You can include requirements that the arbitrators either speak or be fluent in a particular language. It's often the language of the arbitration, but sometimes an additional language. The language of the arbitration can be English. We'll come and look at a provision like that in a moment. But the arbitrators must also be fluent in Mandarin or Arabic or Chinese. One has to be a little careful in drafting these types of provisions. One doesn't want to include a provision that makes it effectively impossible to find an arbitrator, a requirement that any arbitrator be a national of Tonga with experience in telecommunications joint ventures in the Middle East and also speak Spanish. Finding an arbitrator that ticks all those various boxes may be next to impossible. And in addition, like other provisions regarding arbitrators' qualifications, can be fertile ground for challenges to arbitrators after an award has been made. Perhaps we move on to our next set of slides now. The language of the arbitration, which I mentioned previously. This often gets omitted from arbitration clauses, which is a mistake. The language of the arbitration can be exceptionally important, both in how the arbitration is conducted and a party's ability to participate fully in that arbitration, but also in the selection of the arbitral tribunal. It's a very different set of arbitrators that may be selected if the language of the arbitration is English on the one hand, or Arabic or Spanish or Portuguese on the other hand. Language qualifications can be ways of substantially altering the potential pool of arbitrators, and in some circumstances, a requirement that the presiding arbitrators speak a particular language can tilt the possible choice of a presiding arbitrator in a significant way towards one of the parties. It's possible to have bilingual arbitrations. The arbitration will be conducted simultaneously in 2 languages. I think most arbitral tribunals and arbitral institutions shy away from those sorts of provisions. I think most experienced counsel do so as well. Although there's a certain rough justice notion to bilingual arbitrations, both parties get to speak the language of their home jurisdiction. Those types of proceedings can be very cumbersome. They can lead to difficulties in interpretation and translation, which in turn can create potential grounds for challenging an award. Often parties are best advised to choose a single language for their arbitration that is equally suitable for both parties. A typical type of clause doing so, they're easy to draft, is the language of the arbitration shall be either English, Mandarin, Spanish, or something else. Of course, if parties fail to do so, the arbitral tribunal will have the discretion to choose the language of the arbitration. Let's move on though to other potential provisions that can be included in an arbitration clause. A lot of these are nice to have, but not necessary. There are a number of different types of provisions that can be included in an arbitration agreement. You can include provisions that attempt more precisely in a more detailed way to regulate the arbitral procedures. For example, incorporating the IBA's rules on taking of evidence, or including provisions on disclosure of documents. You can include provisions on the costs of the arbitration. You can include provisions for fast-track arbitrations or accelerated procedures. You can see that on the current slide. The SIAC rules already have in them, Rule 5, provisions for expedited procedures if the case has a relatively small value, less than 6 million Singaporean dollars, including all claims and counterclaims. Then the institution, the SIAC, has the authority to expedite the arbitration on request from one of the parties, and doing so over the objection, if necessary, of the other party. The SIAC also has the ability to do so in cases of so-called exceptional urgency. Often emergency arbitration or interim relief from an arbitral tribunal will be able to address issues of exceptional urgency, but nonetheless, there may be cases where a final award is needed within a short period of time. And in those cases, as in small value cases, SIAC has the authority to expedite the arbitration. If that is done, then a sole arbitrator will be appointed, unless the institution determines otherwise, and the arbitral tribunal has the authority to conduct the arbitration on a so-called documents-only basis. No oral hearing, either virtual or in person. And importantly, the final award with summary reasons must be made within 6 months of constitution. We've had a very substantial number of expedited procedure arbitrations at SIAC, virtually all conducted within or well within the 6-month time limit, producing awards that have been recognized and enforced like other awards. During our consultation in the last set of rules revisions in 2016, we inquired of General Counsel, and we'd be interested in feedback from those of you who are in-house on this webinar with respect to expedited procedures. But the feedback that we have had thus far has been that expedited procedures are very desirable, that for small value disputes, it's a very effective way of saving time and money. I think the use of virtual hearings, which we'll come on to very briefly at the end of this webinar, reinforces those conclusions. But one of the things parties can also do, in addition to the SIAC expedited procedures, is include a specific provision in their arbitration agreement. You can see an example on the current slide for a fast-track arbitration, sometimes with 3 arbitrators, sometimes with just a sole arbitrator. The SIAC, like other arbitral institutions, will give effect to those types of provisions. Just as SIAC will give effect, arbitral tribunals will give effect to the opposite types of provisions, i.e. opting out of expedited procedures if for whatever reasons parties don't want a fast-track arbitration.
Jerry, can I interject with a couple of questions here? What if, I understand SIAC as a model expedited procedure clause. If parties have agreed upfront in the contract for expedited procedure, does one party still need to apply to you as the precedent under Rule 5 of the SIAC rules if it wants to go with expedited procedure? And my second question is, if my clause says 3 arbitrators, but then subsequently either side applies for expedited procedure, does it have to be a sole arbitrator? So the clause says 3, but because we're going for the expedited procedure and applying for it, does it mean it's 3 to 1 arbitrator?
Yeah. Let's start with the second question first, because it's a little more complicated. So as you will all recall, in many arbitration agreements, there will be a provision that selects the number of arbitrators. The arbitration clause itself will say the number of arbitrators shall be 3. At the same time, parties will incorporate the SIAC rules or some other set of institutional rules that provides for expedited procedures. And as part of the expedited procedures, will provide that in small value disputes that are expedited, the arbitral institution either shall or may appoint a sole arbitrator. What do we at SIAC do in those sorts of cases? Is there a conflict, so to speak, between the choice of 3 arbitrators and the provision in our rules for a sole arbitrator in expedited arbitration cases? Our answer is no, there's no conflict. The parties simply have provided for different numbers of arbitrators in different circumstances. The general rule for large value disputes or for disputes that are not expedited is that there will be 3 arbitrators. However, if the dispute is expedited because it's small value, then our rules provide explicitly for the possibility of a sole arbitrator, and that those rules prevail over inconsistent provisions in the parties' arbitration agreement. Parties are free to opt out of that provision, free to opt out, as I mentioned previously, from expedited procedures. But if they don't, then they will be taken both by SIAC and Singaporean courts to have agreed to the possibility in the limited category of expedited procedure arbitrations to a sole arbitrator. And we will exercise our discretion as appropriate to appoint a sole arbitrator. That doesn't mean in every expedited procedure case we will appoint a sole arbitrator. We'll take into account the fact that the parties in general desired a 3-person tribunal. And in some cases we may appoint a 3-person tribunal in an expedited procedure case. However, as we all know, conducting an arbitration on a fast-track basis with a 3-person tribunal can be challenging. And thus, depending on the amount in dispute, depending on the complexity of the arbitration, we may appoint a sole arbitrator, notwithstanding an agreement in other cases on a 3-person tribunal. We may also, though, appoint a 3-person tribunal. It is a matter for the SIAC court's discretion on a case-by-case basis, guided, of course, by the specificities of the party's case and guided by the parties' intentions reflected in their underlying arbitration agreement. And then just very quickly, if the parties include a specific provision with respect to expedited procedures in their arbitration clause, it's really a question of what that provision specifically provides. Ordinarily, I think one would need in some fashion to apply to SIAC to expedite the arbitration. That said, you can imagine provisions that, if I can put it this way, apply automatically. At the end of the day, it would be for the arbitral tribunal to interpret the true meaning of the parties' arbitration agreement. But ordinarily, it would, and as an informal matter, parties are always free to discuss with the registrar, the secretariat, how they should approach implementing a particular provision. Ordinarily, parties would make some sort of application to the institution. Perhaps we very quickly move back to the slides, and then hopefully we've got a couple minutes for additional questions, although I think we've taken a fair number already from the audience. Multi-tiered dispute resolution provisions. You often see dispute resolution mechanisms that combine arbitration with something else. The something else can be good faith negotiations, can be conciliation, can be mediation, can be some sort of expert determination. Often these types of multi-tier dispute resolution mechanisms are included with the best of intentions. The thought is, if we can force parties to confer with each other, to negotiate, we can avoid the time and expense of formal dispute resolution, whether it's arbitration, litigation, or expert determination. It's a good thing to encourage settlement. Singapore, of course, has been at the forefront with the Singapore mediation convention in alternative dispute resolution of this sort, and those intentions are entirely understandable. That said, as a drafting matter, one must exercise care in drafting multi-tier dispute resolution provisions. One must draft these precisely in order to make sure that one knows when steps prior to arbitration have been completed. So if the parties are required to negotiate in good faith, one needs to specify how long they do so. If parties are obligated to mediate or conciliate before arbitrating, one needs to specify how they do that, for example, through the Singapore International Mediation Center's rules, and how long they do it, 30 days or some other period of time. Unfortunately, despite their well-intentioned objectives, these types of dispute resolution mechanisms, multi-tier dispute resolution clauses, often lead to disputes as to, well, you didn't really negotiate in good faith for 30 days. And therefore, when you started this arbitration a year and a half ago, you weren't really permitted to do so. Therefore, the arbitral tribunal's award can be annulled. Those types of jurisdictional objections, unfortunately, can arise, and therefore, great care must be used in drafting multi-tier dispute resolutions, either not including them or making it clear what must be done to comply with them. Let's move on just very quickly to the question of virtual hearings. It's appropriate that in a webinar like this, which we're doing virtually, we talk briefly about them, but in the pandemic era, many arbitral hearings have moved out of the hearing room and into virtual space. At SIAC, we've had a number of virtual hearings, both in emergency arbitrations and otherwise, and I know from my experience as counsel and as arbitrator in other contexts that virtual hearings are being conducted literally every day. There's nothing in the SIAC rules that inhibits the use of virtual hearings in an SIAC arbitration. SIAC rules give the arbitral tribunal broad authority to conduct virtual hearings, notwithstanding the objections of one party. Some institutional rules, the ICC rules, refer to a need for in-person hearings, and although there's ICC guidance that suggests that doesn't necessarily mean a virtual hearing, I think many readers would assume that in-person means physically in person. The SIAC rules provide quite explicitly for the possibility of expedited and efficient proceedings, and there's little question but what an arbitral tribunal under the SIAC rules can conduct a virtual hearing, as a number of those tribunals have been doing. I think what we might try and do in the remaining 5 minutes or so is just look very briefly at some pathological clauses, things. So far we've talked about what one should do. Perhaps we talk a little bit about what one shouldn't do, and maybe if we just move straight to some examples of what one shouldn't do. Here's an example of a multi-tiered dispute resolution clause, which it's better to avoid. These are real life examples taken from things that we've seen either at SIAC or otherwise. All disputes arising in connection with the present agreement should be resolved by negotiation and friendly settlement. If this method or resolution should be impracticable, the disputed questions shall be decided in accordance with the rules of the ICC in Paris. Difficulty with that provision is you don't know what it means for negotiation and friendly settlement to be impracticable. How must one engage in negotiation and friendly settlement? Does friendly settlement mandate mediation? All of those questions as to what arguably must occur before you're permitted to start an arbitration are left undefined. If one is going to use a multi-tier dispute resolution mechanism, one ought to include clear timelines as to when an arbitration actually can be commenced without the risk of jurisdictional objections. Let's move on to another example just very quickly. I alluded to this briefly at the outset of our webinar. All disputes in connection with this contract shall be settled amicably by friendly negotiation between the two contractual parties. If no consent can be reached, note that we have there the same difficulty with an uncertain pre-arbitration requirement that we saw in the previous example. What does it mean if no consent can be reached? Reached after how long? After what sorts of things happen? The case of dispute shall then be submitted to the Singapore arbitration body at Singapore. The decision made by this commission shall be final and bind the both parties. Multiple problems. What is the Singapore arbitration body? One doesn't see a reference to the Singapore International Arbitration Center. There aren't many Singapore arbitration bodies, so maybe it is a reference to the SIAC, but it's certainly an example of how not to draft an arbitration agreement. If you're going to submit your disputes to SIAC arbitration, use the SIAC model clause. Relatedly, what does it mean for the dispute to be submitted to the Singapore arbitration body at Singapore? Is that a reference to where SIAC is located? Or is it an effort to specify the arbitral seat? Not really clear at all. Alternatively, is it simply the venue of the arbitral hearings? Again, not clear. A good example of bad drafting in an arbitration agreement. Let's do one more example and then see if there are any concluding questions or remarks from Seok Hui. Another example of how not to draft a provision with respect to the seat of the arbitration. Any dispute arising out of or in connection with this agreement shall be referred to and finally resolved by arbitration in Singapore. And then, just in case you weren't confused enough, the seat of the arbitration shall be England. Is the first reference a reference to arbitration seated in Singapore? If you didn't have the second reference, you'd probably say that's not the best way to pick Singapore as the arbitral seat, but it just barely passes muster. With the second reference, though, which specifically says the seat of the arbitration shall be England, the first reference probably isn't one to the arbitral seat and suggests, although it's an odd thing for parties to do, that the hearings would be conducted in Singapore. That said, one might also interpret this as the selection of two arbitral seats, which you sometimes see in yet more confused clauses. Provisions that say effectively, the arbitral seat shall be Singapore and England. Most courts and arbitral tribunals have interpreted those types of clauses which have not too little, but instead too much of a good thing, too many choices of arbitral seat, as giving the claimant in the arbitration the option to choose which of those two places, Singapore on the one hand, England on the other, is the arbitral seat, the option to commence the arbitration in either place. It's a little one-sided, but on the other hand, both parties have the option to be the claimant. And so each has an equal opportunity. What one ought to do, since we're at a webinar about drafting arbitration clauses, is not do that, not include two arbitral seats or whatever this provision on the current slide says. With that, I think I should turn things over to Seok Hui once again, either for any concluding questions or concluding remarks on behalf of SIAC.
Thank you, Gary. Unfortunately, we have run out of time, but it's been a really informative, very, very interesting session. Thank you for sharing with us your pointers and tips and flagging the pitfalls to avoid when drafting an effective arbitration agreement. I guess the key takeaway is to keep it simple, as always, and to use our, if you're deciding to choose SIAC, to use our model clause. So thank you, Gary, and thank you everyone for tuning in, and importantly, for staying throughout. Thank you and good evening.